My name's Larry Donahue. I've been an attorney for quite some time, and I'm going to try and condense my material down. I do this talk on occasion, and it's meant for half a day. And we're going to do this in 1 hour for the first half, and then another hour on Thursday. So we're going to talk about the top 10 legal mistakes that business owners make, and more importantly, that can and do destroy businesses. I've been a lawyer more than 25 years, actually. I need to update the bio. It's about 27 years. But these top 10 mistakes, I see them over and over and over and over again. They're almost, you can almost say they're our bread and butter because we see these so often. The problem is when it destroys a business, we make money on a business's ability, meaning a client's ability to pay our bill. So if they're going to go and destroy themselves with mistakes, that's not really a great way to build up a base of clients. And so what I really want to see is businesses avoid these kinds of mistakes, which is the point of this presentation. So part one, numbers 10 through number 6, the top 10 legal mistakes that businesses make. First, number 10, ignoring the professionals. And I know it seems obvious, like why would you do that? But it happens all the time. And it's funny because people will, shop around almost like they shop around for a doctor to try and get the right, sort of analysis that they're looking for. And that doesn't always help them, as you might imagine. I think you should be on a first name basis with at least 3 people, a CPA, a banker, and an attorney. Depending on, your type of business and how experienced you are with businesses, you might want to throw a couple of other people there, including, like a coach or a consultant from SBDC would be an example of really good resources. And these people, these professionals are going to be able to do more for you than just simply give you answers to things. They're going to be able to introduce you to people. They're going to be able to, make recommendations. And those things are more valuable than gold when you're dealing with a new business or even a longer term business. In general, when you have tax issues and questions, that's for the CPA. When you have cash flow issues, that's going to be for the banker. And then finally, when you're dealing with third-party interactions, that's where the attorney comes in. For all people, what you want to look for are people who understand your business and industry. April asks, by the way, will this webinar be emailed to you? And we will make it available to you. I don't know if we're going to email it to you or you need to request from SBDC a copy, but we'll certainly make it available to you. You want to find somebody that the people you talk to are not going to sugarcoat answers, but they're going to be respectful to you. And respect includes returning your call quickly and, being friendly and not making you feel like you're taking their time answering a simple question. And then, obviously accessible and willing to introduce you to others. If they're not willing to introduce you to others, their value in my opinion is minimal. Attorneys, I want you to be aware of the internet and the non-lawyers on the internet. I can't tell you just how many things I read on the internet that are just plain wrong. The other issue is there's a lot of my competition, frankly, and there's nothing wrong with them. They're forcing us lawyers to figure out how to provide legal services more cost effectively and quicker, but they do give you this false sense of accomplishment. I love the services on the internet where you go through the process of answering their questions, and then they're like, okay, we're going to go and submit this. And then they're like, rate your experience, and you give it a 4-star because it seemed like it was fine. But, that 4-star then is going to be used to sell their service saying, hey, everybody's given us a 4-star. Well, what the 4-star is for is answering the questions, not whether you were able to successfully defend a lawsuit 3 years later. So I have a love-hate relationship with those things, honestly, because I get a lot of business from screwed up things that were signed or dealt with 3 years ago with an online service that turns into a very expensive, tens of thousands of dollars litigation for us. The other issue is the stuff you read on the internet is not going to be familiar with the local rules or the laws or regulations. I'll give you one example. New Mexico has very draconian, very strict contractor licensing rules on the books. I mean, outrageously strict, to the point where if you're not properly licensed and you perform work, on real estate somehow, an improvement of some sort, they can actually hire somebody else, pay that somebody else, charge you for that somebody else, and also not pay you. I mean, it's a very draconian set of rules that don't exist in most other states. For example, Texas is almost the exact opposite. So you go and get some legal advice about contracting and licensing from somebody who is located in Florida or Texas, you're going to get very wrong information. You want to talk to a lawyer when you're starting out, when you're interacting with just about any third party, landlord, vendor, partners, customers, you're in a dispute, or this is very important, you get a governmental notice. I can't tell you how many demands I'll see from Workforce Solutions, Department of Labor, CID, New Mexico Tax and Rev, and they'll demand some information about this ridiculous thing that you think isn't true. So you respond, this is just false and ridiculous. I'm not giving you any information. Well, guess what? You just close the book on all the facts and evidence and information that you have to be able to prove your case. And so if you appeal it, we can only appeal based on the information you gave them. So you really need to give them an effective reply, even if you think it's a ridiculous request. So talk to a lawyer when you get requests, even things that you think are outrageous or wrong or false. For CPAs and accountants, you need to understand that bookkeepers are not accountants, and accountants are not CPAs. CPAs are certified. They have to take a series of tests and study. They have to continue to do that in order to maintain their certifications. So if you're going to bookkeepers for tax advice, all you're going to get is an answer from them saying, well, this is what I've done in the past. It's not going to necessarily be capable or relevant to what you might hear from an accountant or CPA. The other issue is New Mexico gross receipts tax. It's complicated. It's ridiculous. It's stupid. I cannot wait for the state of New Mexico to get off its collective butt and put in the appropriate tax system. But that's beyond the scope of this discussion. But you don't want to get caught in the middle of all of that. And even if you rely on somebody to tell you how to handle gross receipts tax properly, that is not a defense for penalties and interest if you do it wrong. So you really want to talk to the right professional when you're dealing with gross receipts taxes. The other thing is you don't want to get behind on them, especially things like withholding tax. The IRS treats that as like a trust account, and they will go after you personally, even if you have an LLC or corporation, and you won't even be able to discharge some of those debts in bankruptcy. So you want to talk to a CPA, not a bookkeeper, when you're setting up your initial chart of accounts, when you're trying to figure out how to record, keep track of, collect, and pay gross receipts tax or any tax. You want to figure out what is deductible versus exempt from gross receipts tax. Talk to an appropriate qualified CPA. And then if somebody's telling you, like a customer, that they don't have to pay gross receipts tax, you can't take their word on that. You need to talk to a professional, and you may need to send in or do what's called an MTTC, which is a non-transferable tax certificate. I think I'm saying that correctly. And there's certain rules of when you can or cannot do that. So you really need to talk to a professional about that. Finally, bankers. The first thing you need to understand is tellers are not bankers. Tellers are kind of the low totem pole folks at banks that may not even have college degrees. The other thing you need, and somebody, by the way, said non-taxable transaction certificate. Thank you. That's what an NTTC stands for. The other thing you need to understand is finance companies are not banks. So finance companies, it's relatively easy to get money from them, but it's extremely expensive. They'll have huge upfront fees and hidden costs. They'll require outrageous contracts that are very difficult to terminate. You would like as a business not to do business with a finance company if you could avoid it. Therefore, you really want banks, and bankers will be able to provide very low cost, affordable loans with really good terms. The problem is, it's kind of the weird irony in the world, but bankers or banks, when they're providing loans, they want to give them to people who don't need it, and they make it difficult for people who do need it. So really, the general rule here is if you're a business owner and you think, I don't need a line of credit, that's perfect. Go get a line of credit and don't use it. Just leave it for a rainy day in the background. And if you never use it, great. You spent a little bit of time and you got a loan you didn't, or a line of credit you didn't need. But you want to do that now when you don't need it. And that is going to have very good terms and be a very low cost option for you. The other thing about bankers is they know a lot of other businesses in the industry, and they'll be able to make valuable introductions to other strategic relationships, other possible clients. So finally, I want to give you a real world example here. I'm going to do that for the others, and I'm seeing I took about 10 minutes on this, so I'm going to have to speed up the others a little bit, but I think we're doing good time-wise. But I had a client who was acquiring distressed franchises. And I can't tell you the franchise. I can't disclose client confidences, but this is an example where a client ignored my advice. And the reason the client ignored my advice was they had a hot deal and needed to turn things around very quickly. Specifically, this client owned a number of franchises in the Albuquerque area and had an opportunity to acquire, I think, 5 other locations in the Santa Fe, Espanola, Four Corners area. And my client had to turn around a yes or no answer right away. And what I told my client is like, look, wait a minute, that you're acquiring some significant assets. You have to go through the process. We have to do the due diligence, or we can run into trouble. His response to me was, Larry, God dang it, you're acting like a typical lawyer, slowing things down, and the franchise has my back. I remember that conversation very specifically. And I said, look, the franchise may have your back, but what are they going to do with X, Y, or Z? And his response was, I don't believe that's going to happen. I'm going to move forward with this deal. And so he bypassed me basically and just signed whatever he thought was necessary to make the deal happen. And it was a significant 6-figure sum to acquire these 5 locations. Well, about, I want to say 6-8 months later, I got a phone call from him. And the first thing he said on the phone when I picked up was, if you tell me I told you so, I'm going to fire you. So that would be very unprofessional of me, of course, and I've learned not to say that. But what ended up happening was the IRS had tax liens on this great deal, and those tax liens predated his acquisition of the business, which means he took those new franchises subject to the IRS tax lien. Well, he didn't know about it, of course. And so what happened was the IRS literally showed up with a truck and a bunch of police and seized the assets of those businesses and wanted to know what I could do about it. And the answer is nothing. We're going to have to pay the IRS that money if you want to save those assets. I mean, because at the end of the day, there's certain rules about tax liens and taking from businesses that might have a pre-existing tax lien. So that would be an example of, a very expensive 6-figure problem in not listening to professional advice. Number 9, sole proprietorships or partnerships. So here's what you need to know. If you operate as a sole proprietorship or partnership, you can be personally liable for the harms and damages that are caused by the business. If you're in a partnership, you could be personally liable for the harms that your partner creates or commits in furtherance of the business. So what you want to do is not operate a business as a sole proprietorship or partnership. you want to do business as an entity. The most common structures are LLC or corporations, and I'll discuss that very briefly. What they provide are a number of advantages, and I've listed the four most important ones. They provide liability protection. They provide survivability, meaning if something happens to you, either death or incapacity, it doesn't kill the business. The business can continue to run. It also provides flexibility for partnerships and vendors and other things you might want to do. And there are certain tax advantages that you get when you operate through an entity versus a business just doing it yourself. If you are not operating as an entity, I talked about the liabilities. But here's something more. You can be personally liable for the harms caused by employees or contractors. And think about that for a minute. You can have an employee of your business and you don't even have to authorize the behavior. If that employee does something, even if he or she wasn't supposed to do, and it hurts somebody somehow, borrows money that they weren't authorized to borrow, or signed a contract they weren't authorized to sign, or, heaven forbid, run into somebody on the way, to doing something for the company, you are personally responsible for that behavior, even if you didn't authorize it. So, you better make darn sure you have good insurance. And guess what? Insurance doesn't cover intentional acts. So if you have an employee do an intentional act or harm against somebody, it's very unlikely the insurance is going to cover that unless you have the right type of policy. So having an entity structure would really help out with that. Now, the reason employees and contractors and partners can get you into trouble is because of, it's called the law of agency. They're acting as an agent of the company. And it's what the perception is, not the actual status on whether they're an actual agent of the company. Finally, I want to warn you about what's called a de facto partnership. You have a partnership if you just have a simple meeting of the minds. And a lot of people will get into trouble with this in the very beginning of a company where they're like, they have a friend and they're like, hey, this seems like a great idea. Let's do some research. The moment you guys say, let's do some research, you have a de facto partnership. And if that partner goes and signs a lease, you are probably on the hook for that lease as well, because they've signed on behalf of the partnership, even if you didn't authorize it. So you want to avoid a de facto partnership as much as possible. And usually that means step one is forming a company. And it's not that expensive. Limited liability companies are generally favored because they are very inexpensive to set up, maintain, and close down. They have an operating agreement that acts as a partnership agreement. And so that will sort of control how you conduct business and manage the company and work with your partner or partners. A corporation is a more formal structure. It's more expensive to set up, it's expensive to maintain, it's expensive to close down. So it's generally frowned upon unless there are specific reasons for a corporation versus an LLC. And what I'll tell you, if I had a nickel for every time a CPA or accountant or bookkeeper, it's usually the bookkeepers or accountants versus the CPAs, tell their clients, oh, you need an S corp. And when I ask, are they saying a corporation taxed under subchapter S, or is a LLC taxed under subchapter S acceptable? And then, it turns out, well, yeah, they're not saying corporation, they're saying the tax status. So remember that S corp is a tax status. Even though it has the word corp for corporation in it, it's really a tax status. And so you need to make sure you get that, clarified when somebody says you need an S corp. But so corporations can have two types of tax statuses, C corp or S corp. LLCs can have four types of tax status, S corp or C corp, but they can also have disregarded if it has one owner or it has a husband and wife owner in a community property state. And yes, New Mexico is a community property state. So you can have a husband and wife own an LLC and have it taxed disregarded. Finally, it could be taxed as a partnership. So LLCs have a very, flexible tax capability depending on what it is you want. So I'm going to give you a quick real world example about this. I had a client who had about 6 or 7 locations throughout the Albuquerque metro area. So that includes Rio Rancho and I want to say Berlin. So they had a few stores, and the patriarch died, and it was a sole proprietorship. And so what happened was, instantly, the lines of credit of the business froze. They couldn't even run payroll. They didn't have anybody to sign the checks for their checking account. And so we submitted an emergency petition to probate court. And they took, I don't remember exactly, but I want to say it was like 60 or 90 days to respond to our emergency petition. You can't wait to pay payroll 60 to 90 days. It was ridiculous. So the family pitched in and put in as much money as they can to help with some payroll. And that worked for about 3 weeks. So it literally destroyed a viable business in New Mexico because the patriarch died. It was a sudden thing. It was not planned, obviously. And now you won't see the signs anywhere. They've had to close that business down and declare bankruptcy because once that spinning machine fell on its side and wasn't able to maintain payroll and manage its lines of credits, it wasn't able to get its proper inventory in, business declined radically, the landlord started suing, it just turned into a tremendous mess. So if you have beneficiaries or family or employees that you care about, you really want an entity structure, number one. And then two, you want to think about these things. What happens if you're not available for some period of time? Suppose you're incapacitated and you get into an accident. Do you want to, get out of your coma, 30 days later and find your business is smoldering? Or would it be nice that something is available to keep that thing going and maintaining payroll and so on, so you don't have a destroyed business when you come back to the real world? You need to think about those things. So number 8, poor business naming choices. Do not, please, for the love of God, name your company or products, anything that's confusingly similar to another business or trademark. And I'm going to explain what that means in a little bit. That's a legal term of art that is very difficult for most people to understand. But I also recommend anything that's difficult to spell, generates millions of hits on Google, or is descriptive, right? If I wanted to name my law firm Business Lawyers, right? How are they going to find me? They're going to type in business lawyers and find 50 million hits on Google and not find my specific business. So what I say is naming Nirvana. It's unique. It's easy to spell. It's clever or suggestive of your business. Greyhound Bus is an example of a clever name. Why? You think of a Greyhound, sleek, fast. Greyhound Bus, sleek, fast. That's their, that's kind of what their brand is. Ideally, the .com is available. You really need to avoid the love affair of falling in love with a specific name. You need to be wise and come up with a number of different names and do the analysis. Is it available? Can you get the .coms and, or whatever's important for that specific business? And the reason I say that is I make a lot of money on people falling in love with names and then having to fight about it. And I just think, I'm sorry, I know this is probably not politically correct, but I think it's the dumbest thing in the world. If you're trying to start a business from scratch, you need to worry about payroll and advertising and, getting the licensing and inventories and everything else. And now you want to spend thousands or tens of thousands of dollars with me fighting over somebody over a name? That's just dumb. It's just dumb. But I make money on it, and it's a common problem I see over and over and over again. So what is confusingly similar? That's a legal thing. It stands for likelihood of confusion. And that's the standard legal definition of a confusingly similar name. And it's not a direct hit or exact match. You don't care. I mean, you care about those, but that's not the hard part. What you care about are names that are similar in sound, look, or meaning. They're going to cause problems for you. The other thing is if you have a descriptive name, you can't protect it. So you know, Billy Bob down the street, who is a former employee of yours that learned exactly how to do what it is you do, goes and opens up a new business. They can name their business the same thing if they want to. So don't do that. You know, what you want to do is look at this spectrum I have here. You have generic on the left, arbitrary on the right. So generic, Albuquerque's Best Hamburgers. You know, that's going to be generic / descriptive. You cannot protect those names. On the other side, I gave you one suggestive name already, right? Greyhound. But you know about arbitrary names, don't you? Apple. Microsoft, I would argue, is probably suggestive versus arbitrary. Amazon is a good arbitrary. We business owners really don't like arbitrary names because you don't have the source connotation. You know, if you came up, let's say you're a computer repair company in Albuquerque and you want to name it Zebra. It's hard for you to do that, right? Because Zebra has nothing to do with your business. So most business owners don't like to do that. But if you do that and you put a lot of, you know, time and advertising dollars into that name, eventually it becomes extremely strong because, you know, Apple, Amazon, those are great names. You type them in, it's you know, it's not descriptive at all. So they can protect it and they can enforce it, and it becomes valuable in of itself. The name becomes valuable.
Larry, I have a question on that. When you were talking about hamburgers, but what if you only sell hamburgers? How do you choose a business name that says, I sell hamburgers?
Agreed. You know, branding is kind of off topic because I'm not a great brand person. I know what I like and don't like. But I'll give you an example, like Harry Carey's. You know, that is a name of a hamburger franchise in the Chicago metro area. And it's doing really well. And it doesn't say Harry Carey's hamburger joint. It just says Harry Carey's. And guess what? Those guys own the trademark for Holy Cow. And does anybody know or knew of a company called Holy Cow in the Albuquerque area? So 7 years later, the Chicago folks went after the Albuquerque folks. So you may think you're using a different name or being clever, but you got to make sure nobody else is using it. But that is a great question. You know, how do you find a good name that is suggestive of what you do versus being descriptive? And that's a hard thing. It's not an easy thing to do. I agree. So I want to give you some examples of the problem with likelihood of confusion. And so what I mean by this is if you're picking a name, you need to figure out if there's another problem out there. And another problem could be the following. You know, if you have somebody has a synonym of yours or an abbreviation or a translation, you can see on the right here what the trademark office does. And that means trademark infringement. So if somebody has a name that meets these categories, you can run into problems. And for example, the really hard thing I've had trouble with is the fifth one down, where you have common words that are similar in an industry, even though they might not otherwise be common in the English language. And I have an example here, athletics versus running. So if you had a gym shoe and you wanted to call it, you know, Speedy Athletics, well, athletics is going to be translated to running or other words in your industry, and you could be sure that other people are probably going to be there and create problems for you. It's very confusing. The other thing is that last piece. If I had a machine learning company, so as Larry's Fast Machine Learning, well, fast machine learning would be descriptive of my business. So just take them out, pretend they're not even there. And so what you're left with is just Larry's. That's the one descriptive term for that name. And so you really, adding additional words that are descriptive to a word that is maybe more distinctive isn't going to help you. So naming is a big issue, and I would encourage you to hire a branding expert. I did that for my firm, and it's not that expensive, and they'll give you some good options and make this their problem, not your problem. Focus on the other things: customers, employees, payroll. So finally, let me give you a real-world example here, and that is Melon Rancher. I have an e-cig client who had a product called, when I say product, a fluid, an e-cig fluid. I'm not a e-cig person myself, but they had hundreds of different fluids for their business. One of the 100 was named Melon Rancher. Well, the company called Jolly Rancher found out about it, and they were none too pleased. So they went after my client. And when you infringe on a trademark, you have potential attorney's fees, you have lost profits of them, they can disgorge your profits, they have significant penalties that they can use against you. So they wanted the profits from my client. Well, this was one fluid of over 100. And guess what? My client doesn't keep business records saying, well, in today's, sales or receipts, this fraction of a percent went to Melon Rancher versus the others. Everything was just combined. So what do you think Jolly Rancher said? Not my problem. You need to cough up the profits. And if you can't figure it out, then we're going to just presume what the business earns. So we had to, having spent a lot of money trying to fight that, and my client had to write a check to Jolly Rancher that my client wasn't none too happy about, unfortunately. So let's go to the next one: copyright law and work made for hire. This is a common issue. And by the way, before I go forward, Polly asks, how expensive is it to trademark your name? And the answer is, it's not that expensive at all. The USPTO charges $250 per trademark and per class code. So let's say you are a consultant, so you provide consulting services and you write a book. That would be 2 class codes, one for publications, and there's further subclassifications depending on online downloadable versus something else, and then the consulting services. So it'd be $250 times 2, or $500. The other issue is there's word marks versus logos, and those are really separate. Words are stronger too, so you want to protect the word for sure. If you care about the logo, then the logo second. And again, those would be 2 different trademarks. And if you have 2 class codes, that can start increasing on the costs. And then you have, if you're going to do it yourself, that's all you have to pay. There are some intermediate expenses depending on how you handle it, but it's not that difficult or expensive. On the copyright stuff, what you need to understand is authors own the copyrights of the works they create. There's only one exception, and that is if the author is a properly classified W-2 employee. And so what do I mean by that? Well, let's say they're improperly classified. You say, oh no, he's an employee, but it turns out he's actually a contractor. Well, then he can use that against you, even though you were doing withholding and everything else. So what is a copyright? A copyright is an exclusive right to do something with a work. So that's the do something is like sell, transfer, publicly display, and also create derivative works. And that's really important when we think about like applications, photos, images, and I'll explain a little bit more in a minute. But you have 2 big problems with this as a business. First is, if you pay the contractor to do something for you, the contractor still owns the copyright unless you have a specific contract in place with a work made for hire clause. The other issue is if you hire anybody, employee or contractor, and they do something for you, and they copy somebody else's work, like they go to Google, and we're going to go into a little bit more detail. They go and copy somebody else's work. even if you did not give them permission, even if you had no knowledge, it doesn't matter. You and your business are strictly liable. And when we're talking about copyright infringement, that's a big problem. If it's copyrighted, meaning they actually obtained a copyright, submitted to the Copyright Office, statutory damages and attorney's fees are available. And statutory damages start at $75,000 per infringing use. We do have a question from somebody. When I give my formula to a factory to manufacture, what are my rights? That's actually a very big question, and it's going to be a little bit out of the scope of this, unfortunately. So I'd encourage you to contact me afterwards. I'll be happy to give you a more rigorous answer. The quick answer is your rights are whatever you've perfected. So copyrights, if you have an expression like a photo, a formula, a training process that is an expression of you, that is protectable if you copyright it. Otherwise, a patent, if you have an invention or something that is patentable. Finally, you have trade secret or contracts. So contract is really going to be the sure thing to lock other people in that you have a direct relationship with. Copyrights, patents, trademarks, they help you with the rest of the world. So if you don't have a relationship with somebody, they still can't go and copyright your stuff. And that includes trade secret as well. But there's a whole nother issue with trade secrets and how you handle that. The next thing is, I want to give you an example here. We're going to use statute of David. And by the way, yes, I paid for this image. I went to one of the image stock companies and I paid for the image and downloaded that. Because why? I would have violated somebody's copyright if I did this. I went and Googled statute of David. Just because I Google statute of David and there's all these pictures here doesn't give me the right to go and grab one of these and put it on my website or my presentation here. And if you do that, or if one of your contractors or employees does that, you're giving somebody an opportunity to go sue you for $75,000 per infringing, use. So you don't want to be Googling and looking for images on Google. Just don't do it. You want to go to one of the imaging, there's a lot of really great sites out there that will sell you licenses to images. And that's what you want to do. And by the way, I'm picking on images, but don't let that confuse you. This is the same issue for videos, for music. You have this problem with copyrightable work product. Now, the other thing I want to bring up about statute of David is, let's pretend I'm Michelangelo. I should be such a genius. And you hired me to produce that statue. Well, I produced the statue for you. Under copyright law, you own the statue. I own the copyright to the statue. So question one is, can you take a photo of the statue you paid for and sell that photo or display that photo somewhere? The answer is no, because I, Michelangelo, own the copyright. Therefore, I alone am entitled to what's called derivative works. A photo of a statue is a derivative work. And you may see this when you watch a movie or something on Netflix where there's a picture on the wall, but it's kind of grayed out or fuzzy. The movie or the show is a derivative work. And the photo or the picture on the wall is an original work. So instead of going to get permission or paying for a license to display that image in their movie, they go and they just gray the thing out. So you see this actually more often than you might imagine, and you don't want to get into that trap as a business yourself. So I want you to beware with all of these things, music, software, apps, logos, websites, web apps. The only way to deal with this copyright problem is one, have a contract with your contractor. You should have it with your employees as well. that assigns all the rights back to you with a work made for hire clause in it, so that you will own the copyrights of the work that they produce. And if they're not willing to do that, find somebody else. There's enough people in the world. There's enough photographers in the world. Don't deal with that BS. Find somebody that's going to take some pictures of your business or you or whatever the pictures are and give you the copyright so you can do whatever you want with them and not have to pay me later to deal with some sort of nightmare because that photographer went and really liked your images and sold them to somebody else, and now they're trying to enforce the copyrights. You also want to make sure that all accounts are owned by you and paid for by you. So don't get in the trap of hiring a consultant or a marketing person that's going to do all of this for you. It's fine for them to do it all for you, but we don't want them to own the social media account. We don't want them to own the domain name or the website account. You need to own them, and then you can give them permission or access to your accounts to provide the services that you need. There's a question here, and it is, there are some companies who sell the same logo for thousands of companies. What should one be aware of when this happens? The answer is, if you're going to get a logo, you want to make sure it's exclusive. You're going to pay more for that. So you're really going to see that in the price, where they're reusing content and logos over and over and over again. And you need to avoid that, especially with logos, because a logo is less a copyright issue and more a trademark issue. And with trademarks, the naming issue also applies to images. So you want to think about likelihood of confusion, and you don't want other people to be using that image wrong. So you want to pay a little bit more for a custom work that they will produce for you. The final thing I want to mention about copyright law is I see this over and over again where people will hire contractors from guru.com, for instance. And there's nothing wrong with that, except you really need to be careful with who you're hiring. So if you hire somebody from India, for instance, or you hire your niece here in the United States, the question is, can you hold either party accountable if they go and download or copy somebody's image? So you really want to maybe pay a little extra, and you want to pay for somebody you can hold accountable, and that they can back up their work, and they have the experience to know not to go and copy other people's work, or they might have errors and omissions insurance. Ask for that. Make sure that they have a policy for you and that you can find them, because I promise you, if something like this happens, you're probably not going to hear about it right away. You'll hear about it in 5 to 10 years when you've totally forgot who the heck you hired to do your web page or your web app in the first place. Now, I want to tell you about a quick real-world example. There was a multi-million-dollar e-business in Santa Fe that hired me because for years they had this contractor that they were paying to do their e-commerce website. And so this contractor was doing everything, managing the website, the inventory, keeping it running and live. And this was a valuable business for this contractor. Well, the e-business kept growing in value to the level where they needed to hire more people, get more horsepower. They wanted to bring the business, the work in, because it was becoming so valuable that it was overwhelming their other aspects of their business. Well, this contractor said, "What are you talking about? This is my website. I'm licensing it to you. And if you don't want to do business with me, go away. I will go and use this and give this business to somebody else, or I'll just take it for myself." And my client didn't have any contracts in place. They did not have the branding in place. So it was kind of a generic thing. They all the accounts, the social media accounts, the domain name, the website were all owned by this contractor. And the contractor, when we went and prosecuted them, was basically lied and said, "Hey, this is my stuff." My client never reimbursed them for for the names, and never took ownership of all of that. So I was having to prove ownership issues on top of relationship issues and copyright issues. And it was a very, very, very expensive of litigation that was not successful for our client. So you never want to be in a situation like that if you can avoid it. Finally, we're going to talk about number 6, poor or no contracts with third parties. So you need to understand contracts are critical. And it really cracks me up in today's political world. I don't understand. We'll let politicians just say whatever they want without any truth or reality coming out of their mouths, and that's okay. But then when we shake hands with people in business deals, well, we expect them to honor every single word that comes out of their mouth. And there's no in between. I just don't understand that. It's like we as a society have flunked ourselves back down to kindergarten. But we're talking business. So forget about politics and forget about handshakes. We care about enforcing important relationships. And that's what contracts are for. And hopefully you'll never have to refer back to it because the relationship is great. But if the relationship fails for some reason, then you're really going to care about things like maintaining accountability or responsibility, ensuring you get paid if you're supposed to get paid, allowing you to terminate if things aren't working out for you, limiting warranties and indemnities and liabilities so people don't come back after you for some reason, controlling dispute resolution, avoiding expensive lawsuits. The list is extensive here on why you need a contract. Confidentiality, non-compete, non-solicitation, hiring your employees or going after your customers. Do you care about those things? Do you have trade secrets you need to protect? Do you care about, the length of the contract? Do you care about how a lawsuit might happen? Or are you okay with that? Are you selling products or services to somebody in New York? And if they decide to sue you, do you care? Are you okay with going to New York or Manhattan to defend yourself? So contracts are really important for these reasons. There are some things in New Mexico law that you may find surprising. And the one thing, and I list them down here, and you really need to know these. One is the Unfair Trade Practices Act. It requires some sort of malfeasance on your part. You can't apply UTPA to consumers, only to businesses selling things. So if you said something erroneous about what it is your product or service can do, or even if you didn't say anything erroneous, but the other side is lying about what you did or didn't say, that can be used against you. And that, again, will allow 3 times damages in attorney's fees if they can prove their case. So that can really be a problem, and you want to make sure you have the right contract to protect yourself. There's also what's called the merger clause and parole evidence rule. And you really need to know this. If I give you a contract and then I start telling you what's on the contract and you sign it, all the words out of my mouth are irrelevant to what's on that contract. What matters is what's on that contract, not the words. So if you ever deal with a sales associate or executive and they're like, oh, well, don't worry about that, we'll take care of you. If it's not in the contract, they're not going to take care of you. I mean, they might, but you won't be able to enforce it if they don't do what they say they were going to do. So you have to have it in the contract. 2 other things you need to know about is the drafter's rule. So this can really be used against you because as a business, you want a contract. But if you do a crappy contract, pardon my language, that can be used against you because you're the drafter of the contract. And the rule is that ambiguities are interpreted against the drafter. So you want to have a contract and you want to have a quality contract. Finally, attorney's fees clause. Please put it in there. I'm not saying that because me, lawyer, wants to get paid, but it prevents frivolous lawsuits, number 1. And then 2, a lot of small businesses have disputes in the range of like $1,000 to $10,000. And if you get me involved and I got to sue somebody, I need a $10,000 retainer. So how do you justify paying me a $10,000 retainer to go chase after somebody for $2,000 or $3,000? It just doesn't make sense. And it's really hard for you to get competent legal help when the dispute amounts are small. But if you have an attorney's fees clause that allows you to also demand attorney's fees, and guess what? The other side might be willing to say, hey, you got to go and sue me for this $2,000. But now if they have to pay attorney's fees, they're going to be much more interested in negotiating than having to actually fight and then have to pay our fees on top of it if they lose. So that's why you care about attorneys' fees. So I talked about high quality standard contracts. One thing I want to suggest is, do you generate proposals or statements of work or estimates to get people to agree to do business with you? If so, I recommend you separate the legal from the proposal. So get people to say yes first. And that needs to be your best foot forward. Good looking document, your logo on top. You put legal language in it. Do you like to read legal language? I bet you don't. And that just causes people to freeze up, to delay making an answer or saying yes. So get rid of all of that. Get them to say yes first. Now, give them the contract, and signing the contract is a formality. So it's sometimes with companies, it's a different process. It's a different team. They're just there to review the contract because the deal's going forward. So if you have a proposal, take the contract out and then incorporate the proposal in that contract. And you can also do the same thing with intake forms. So let's say you're a repair shop, for instance, and you're going to do a cost estimate. Have a really good looking front page, be smart. And Google smart goods, specific, measurable, attainable, realistic, time bound. Put that in your intake form on the front. So that's what people are going to agree to. And then they can flip it over to the other side for the legal language if they even care about that. Also, if you haven't figured it out by now, you need a good contract for your employees as well as your contractors. And my advice is strive for one template for all customers so that you don't have to keep paying the lawyers every time. But then that requires you to think about it. What is the standard stuff that applies to everybody? And then what is the non-standard stuff that you adjust from time to time? That will be an exhibit or an attachment or something that you can just change from one client to the next that incorporates the whole package. And that will really help you out a lot. I do want to tell you about some COVID-19 issues real quick. We got a few more minutes and I'll speed through this, but it's important. One is you need a force majeure clause, especially dealing with language for pandemics. But it's not just simply, you do something. You got to think through the issue. How long does this last? I mean, we've been in a pandemic now for over a year. Would you want to terminate, or do you just want to delay or suspend performance? You got to think through that. The other issue is you have shifting rules impacting performance and delivery, and that's going to be affected on a local and statewide basis. So you need to think through those issues. And then finally, I really encourage everybody as a business, if you have non-essential businesses as clients of yours, think through how you can help them. They need help. They need flexibility. So they are going to favor those vendors that are going to give them flexible payment terms, or maybe provide lower end or less costly options while they can only service 0 to 50% of their normal customer base. And I would encourage you to do that because I'm sure they're going to be loyal to those businesses that have helped them out through these hard periods of time. So I ended up blathering on a long time, and I apologize. We don't have a lot of time for Q&A, but I want to open that up now. Please give me your questions while we have a few more minutes. And the cement resurfacing company is this. They did not have a good warranty clause. They went and resurfaced cement floors in an expensive custom home, which happened to have a faulty foundation. So, which was owned by an expensive doctor who kept demanding they come in and redo their work. They finally hired me when it came to like number 6 or number 7, because they were looking at an open-ended thing here when it clearly wasn't the fault of the surfacing material. It was the fault of the underlaying foundation that were causing all these cracks. Don't put yourself in that. Limit the warranties. Make control, if there's a problem, what you can do and how you can do it. There was somebody that asked, they missed a part about registering a trademark. You can go to the USPTO for that, or literally there's many, many organizations that can do that. I will tell you that if you do the trademark registration yourself or you hire a non-trademark lawyer, there's over an 80% failure rate. If you hire a trademark attorney, the failure rates are a lot less, although I'll be honest with you, my failure rate isn't zero, but I don't think it's my fault. Mostly, a lot of my clients just fall in love with a name and they say, register it anyway, even though I tell them it's probably going to fail. And please, I'm happy to take emails offline and answer questions for people or point them in the right direction, or the New Mexico SBDC as well. Their consultants are available to answer questions and point people in directions as well. I'd really encourage everybody to do that.